Hello and welcome to your real estate journey, expert tips for buyers and sellers. I'm Dolly Lopez, your realtor and broker in the state of Florida and Kentucky. And today, like every Thursday, I'm joined by one of my favorite real estate attorneys, Valerie. Welcome. How are you?
Good. Thank you. Super excited to be back with you and all your followers.
I am very excited to have you on board. I love Thursdays because it's just about law, the legal stuff about life that we don't even know about and
Yeah.
how to proceed. So, anyways, today I wanted to talk about how to cancel a contract after an inspection period.
Mhm.
Buyer and seller. Let's talk about a buyer first.
Okay.
After the inspection period, they decide to cancel the contract. How can they go about doing so? And is that even legal to
Right.
do?
So we always have two different kinds of contracts, right? We either have a cash buyer or we have a buyer subject to financing. A buyer that is subject to financing still has a right to cancel after the inspection period if the cancellation is because of the financing. Meaning, the lender has come back to the buyer and said, hey, listen, I'm so sorry. Within the financing period, right, which is typically 30 days. So within that financing period, your lender comes back to you and says, I'm so sorry, you don't qualify for your loan. Here is your letter letting us know that you don't qualify. So in that case, the buyer can cancel, no problem, send the cancellation with a return of the full escrow deposit.
Okay.
Now, let's switch sides. If we have a buyer who's buying cash, who decides after the inspection period that they want to cancel because they simply don't want to buy this house anymore because of XYZ reason. In that case, now we have an issue because now that's considered a breach of contract on behalf of the buyer. And you're going to have to negotiate with your seller as to whether they want to return the full escrow deposit to you or not. And I can tell you 99% of the sellers are going to fight and say, I'm not giving you back your escrow. I'm taking that money because you're canceling outside of your inspection period and you're breaching your contract. So, what happens in that situation? What happens in that situation is now everybody's refusing to sign. Pursuant to the contract, we have 10 days for the buyer and for the seller to come up with some kind of agreement as to how the escrow deposit is going to be dispersed. Whether it be 50% buyer, 50% seller, 70% buyer, 30% buyer, seller, whatever the agreement may be, you have 10 days to do that. And let's say that within those 10 days, you cannot come up with an agreement. Well, pursuant to the contract, you have to go to mediation. And a lot of people don't know what mediation is. So, mediation is outside of the court, right? This is not something that you go to the courthouse for. Mediation is simply a time where both buyer and seller can get together with a third party called the mediator. The mediator is typically either a retired judge, retired attorney, someone who has been in the legal field for quite some time and who is unrelated to all the parties involved, right? Unrelated to the title company, unrelated to buyer, unrelated to seller, unrelated to the realtors, unrelated to the lender, someone who nobody knows.
And
And
who picks that mediator?
that mediator has to be picked by both buyer and seller. They have to agree as to who it's going to be. Okay. And then typically that mediator is going to let both sides know, hey, listen, this seems like a good offer because of da 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 da. And usually the reason why clients, in my opinion, tend to listen to mediators is because they really are not biased. They're not there for one side or the other. And they have the experience of saying, hey, if you do go to court, know that this could happen. Know that I've seen this happen. And this is your best day. You should accept this. Or you're looking to spend this much more money if you continue and want to litigate this case and actually take it to court. So it's the mediator really does help both sides come to an agreement. If for whatever reason the mediator was not successful and they couldn't agree to anything, well then the next option would be taking the case to court and actually litigating it and waiting for your trial.
Got it. Okay. So, what happens now? Let's kind of change it a little bit. What happens when you are canceling the contract due to a contingency not being met?
Mhm.
For example, during the inspection contingency, they have X amount of days to do the inspection and get out of the contract if they wanted to.
Mm-hmm.
They also, if you are financing the property, you have the loan contingency period. And after, and let's get this clear, loan contingency, by the way, because in Florida, there's a lot of realtors that they don't, either they don't know how to explain it or it has not been explained to them. A loan contingency really doesn't mean a conditional approval. A loan contingency, it's a clear to close.
Mm-hmm.
Plus, for any after a clear to close, you are closing on that deal.
Correct.
After a contingency approval or a I forgot the word, but
Loan approval is
after this loan, the conditional approval from the lender is a conditional approval. You still have to provide certain documents.
correct.
Your time that you put on the contract, it's just for thinking that it's not a clear to close, and then you cannot close, you're losing that deposit.
100%.
Most likely. So you guys, please represent your clients properly and properly. A loan contingency really means a clear to close. It doesn't mean a conditional approval. Anyways, I just need to say that because for some weird reason, I keep hearing a lot of people, agents say, I need a loan contingency no more than 15 days. I cannot get a loan approval, a clear to close within 15 days. So anyways, but let's say, going back to this, let's say that we are within our right to cancel the contract. And we did. Let's say that we're a buyer and we cancel the contract within our rights. But the seller does not want to sign that release, because in order for you to release those escrow funds, you do need both parties to agree to be released to whichever person.
Correct.
And if if the seller doesn't want to sign that release, then what happens? Well, we're clearly within our right.
Right. So in that situation, and what Dolly was saying is, as a title agent, as the attorney handling the file, I cannot just release the money back to my buyers because I believe that my buyers are legally entitled to it. I don't have the right to do that. In order to release funds, I need for a release and cancellation to be signed by both buyer and seller. So if we're in a situation where the buyer is canceling within their contractual rights and the seller refuses to sign that cancellation, well, then the buyer has no other option but to take that seller to court to force him to sign. And something that we should know is, when you do go to court, and let's say you're in a situation where seller refused to sign and seller should have signed legally because buyer was in his rights or her rights to cancel the contract. Well, now the seller is looking at not only having to sign the contract, right, the cancellation, but also having to return any attorney's fees and costs that buyer had to spend in order to get to court, to get a judge to force a seller to sign. So, and that's very important to know, because now a seller is not only paying, or is not only releasing $5,000, let's say, or $10,000, whatever's in escrow, but now you're also probably paying another $15,000 to $20,000 in attorney's fees and costs, because that's what it took for the buyer to be able to get their money returned.
So how many days does the seller have from the moment they receive a release to sign that release?
Right. So
the buyer can actually take action.
Right. So there's actually 10 days. It's 10 days for the buyer and seller to be able to come up with an agreement and sign the cancellation. If within those 10 days they cannot come up with any kind of agreement, then, like we had mentioned, mediation. If in mediation we cannot agree to anything, or let's say we cannot agree to a mediator, right? Let's say that we get to the mediation period and we just can't agree to a mediator. Well, then we have to sue. We have to go to court. And what people don't understand with going to court is how costly and how long a litigation can take. So the higher the escrow, the more likely I'm going to tell you we should go to court. The lower the escrow, the less likely it is I'm going to tell you we should go to court, because you're going to be spending a lot more money and it's going to be taking a lot longer for you to get that return of that money. So it's court really is kind of a last option, only because of the longevity of a litigation and how long it can take.
Let's say that the escrow amount, it's about $3,000. So not much at all. But there's still the